Cheer up, Mr. Chair.
I'm good. We just had dinner.
Relax.
Good evening. This is the House Judiciary Committee. It is April the 7th at 7 o'clock in the evening. We have a couple bills we're going to deal with tonight. The first is Senator Peters' bill. Senator Peters' bill is the cross-file of Delegate Watson's bill.
Move favorable.
Yeah, okay.
Second.
It's a favorable and a second. I wonder if there's any further discussion on the aptly named House Senate Bill 666.
Can we
That far.
can we hold this bill?
Yeah, I'm going to use my hold.
Oh, y'all treading on thin ice.
Mr. Chair, I have a question about this bill.
Do you really?
Yeah, I do.
Oh, is that right?
What date? Does it have a certain date everything has to be changed by?
I don't know.
Okay.
I don't know. I think my answer to that question is I actually think I don't care anymore, but that's fine.
He's not a fan.
I'm sorry I asked.
No, it's all right. We're going to do it for Delegate Watson, Senator. All right. So again, the aptly numbered Bill 666. We're on a favorable, it's a straight favorable. Vice Chair, okay, ready to go. With the roll call, the Vice Chair.
Yes.
Is Anderson here? Kurt is not here. Again. Lauren. Delegate Erican?
Yes.
Okay. Bartlett,
Yes.
Carden.
Supremely yes.
That's just horrible.
Oh,
God. Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone, Mike Malone, Mike,
I'm converted. Yes.
yes.
Hello.
damn it. All right, McComas.
For Ron, yes.
Oh, now we're doing it for Ron?
Oh,
It's going to be expensive.
Moon,
yes.
Shetty,
Yes.
Cham.
Yes.
Wow, that's fantastic.
3 times.
Ron Watson,
Yes.
Nicole Williams.
And since I can't special appeal it, yes.
Well, you know. All right,
All right.
that's fine.
Can I be heard now or not? Are you hearing
Yes,
me?
I can hear you. Yes, we
Okay.
can hear you. So for the next part of our voting session, I think if I'm not, my suspicion is that delegates Cham, Cox, and Erican are in the same place. And I'm saying that it's fine. I just think for the purposes of being able to speak, if one of you talk, then the other two should mute your computer so that we don't get the feedback from the other two. As your sound engineer, just trying to help. That's why I'm just wanting to make sure that we don't have a lot of feedback right now. So, all right, Senate Bill 190. All right, Senate Bill 190, in the part that was sent over to us from the Senate, says that a person may not be denied the right to purchase, possess, or carry a firearm under this title solely on the basis that the person is authorized to use medical cannabis under the Health General article. Over the last couple days, and even before that, Delegate Lopez has been working on amendments to her ghost gun bill. In the last year, in the city of Baltimore, there has been a steady increase in the number of ghost guns that have been seized as after crimes have been committed in Baltimore. In 2019, there were 30, 127 in 2020, and 53 in the first 3 months of 2021. There's similar, and these specifically are the polymer 80s that are coming back. In Prince George's County in 2019, there were 27. There were 162 in 2020, and in the first 3 months of 2021, there have been 69. Steady increase in these guns being found in connection with criminal acts. These are showing up more and more on the streets of Baltimore and across the state. And for that reason, I think it's important for us to at least begin the conversation as to what we should be doing related to ghost guns. And so to that end, the committee has an amendment to Senate Bill 190 that would add an amended version of Delegate Lopez's ghost gun bill onto Senate Bill 190. Delegate Lopez, would you talk about not only what the bill does, but the changes that you made to Senate Bill 190 after the hearing, based on what you heard from the opponents of the bill? Could you identify those things, and then we'll go from there and take discussion?
Sure. So HB 638 did a couple things. One, it moves unfinished receiver into the part of the code that talks about regulated firearms. And so when you do that, you trigger a couple things. That means that in order to purchase one, you have to have an HQL. Part of the HQL process is getting a background check. And so that's how we get a background check on an untraceable firearm. The other thing that it does is that it requires a manufacturer before the point of sale to have serialized the firearm with the same federal standard that a finished receiver would have. The other thing that it does is that it clears up the ambiguity that's in the ATF regulations about what hobbyists can do. The amendments to it, there's 3 amendments. The first takes out language that the state's attorneys had an issue with. It basically took away their prosecutorial discretion and gave more discretion to judges. And so that made sense to me. And so that was an amendment to take that out. There was another amendment that I'd really kind of chalk up to like a drafting error, like that had to do with record keeping. We said in the original version of HB 638 that FFLs would have to keep up with federal standards for record keeping, but it didn't quite specify that we were talking about the unfinished receiver as well as every other type of regulated firearm and any other type of firearm that they might do a background check or A&D or anything like that. So that was the second amendment. The third amendment came directly as a result of the testimony that we received in the hearing that I heard from basically every hobbyist who testified, and that was that trying to use the type of equipment that a hobbyist might have to engrave all of the federal requirements for serialization on the receiver itself might be a little bit tricky. People have long names. People, might just want to take more artistic license and put it on other places of the firearm that mimics what an actual manufactured or imported firearm might look like. I didn't have a problem with that. The law enforcement officers that I spoke to didn't have any problem with that. They just wanted to make sure that there was the same serialized information that would help them trace everything. So that is a comprehensive look at what this amendment does.
We'll take questions on the amendment. We'll start with Delegate Conaway and then Delegate Griffith.
Thank you, Mr. Chairman. So we're trying to add HB 638 as a complete amendment to,
It's an amended version of HB 638.
okay, and so you mentioned a polymer 80. What is a polymer 80?
Delegate Lopez?
Sure. Polymer 80 is a type of unserialized, or a very popular, I should say, unserialized receiver that you can buy. And polymer has to do with the substance that it's made out of. Polymer is a composite of a bunch of synthetic organic materials like plastic or resin. And so it's a very popular company because they've realized that there's a market for people who want to buy essentially gun kits and receivers. And they've also realized that people want to buy the machine because that can be difficult trying to mill out and drill your own receiver. So they basically, it's a one-stop shop for how to put together your own firearm that would otherwise be restricted.
So is this receiver as strong as a regular receiver? Let's say, is the polymer receiver as strong as, let's say, a Glock receiver? I mean,
yeah, so it's funny you mention that because Glocks are made of polymer. That's one of the defining characteristics of a Glock, is that the frame is made from polymer. But yeah, they're just as strong and effective. I mean, we had a video that was circulated by the Baltimore Police Department of someone shooting at an officer with a polymer 80. And there's been at least 15 people killed in Baltimore City from polymer 80 guns. So they're just as lethal as, traditional AR-15.
okay, and so if a person doesn't get rid of their unserialized, whatever you call it, frame or receiver before January the 1st, 2022, what is the certain penalty?
I believe it's a misdemeanor of, I want to say it's 5 years or $2,000 is the penalty. But what we've done is created a pathway so that if you have one of these, you can make it legal by serializing it. Because some of the testimony that we received from the hobbyists was that, actually all the testimony we received from the hobbyists is that they don't want these things banned. They want to still be able to do them. However, if you're caught with one of these unserialized firearms, there's now a penalty where right now there isn't one.
So if a person has one of these and they already weaponized it, I guess you would call it, then they would have to take it back apart and put the serial numbers on it and all of that?
You wouldn't have to take it apart. You would just have to engrave it with the same information that a normally purchased firearm would have.
And then if you're a person that is forbidden from having one of these firearms, then what happens?
You would go to jail, right?
So
There's already
turn
very
the number in. Do you turn the number that you're going to engrave on this? You had to get this from a gun dealer, or?
No, because that would be akin to a registry. So as long as you know the number on your firearm and it's unique to all the firearms that you've made, it satisfies the federal requirement. So it's like a serial number on a firearm isn't the same as a VIN number on a car, where like one VIN number is unique to all the cars that have been produced. A serial number on a firearm is just unique to the manufacturer's inventory.
Right. So where would the person get that serial number from?
They would just make it up. Like a unique serial number could be 1, 2, 3, 4, because the rest of the information on the firearm is what helps a law enforcement officer determine its origins. It's not just the number.
Okay, thank you very much.
Delegate Griffith?
I have a ton of questions. So question number one, so the penalty for this, does this put this in line with having a stolen firearm right now?
Let me double check. I think they're pretty similar. But the overarching issue is prohibited people having these to begin with, right? So all the
sorry, go ahead. I'm sorry. I apologize.
No, go for it. It sounds like you know what the penalty is for a stolen firearm already.
Well, I mean, I believe, and if the chair could correct me, I believe it's 6 months and $1,500 for a stolen fire. I apologize, Mr. Chair. Do you know what the penalty is for a stolen firearm?
Well, I mean, are you talking about the theft of a firearm?
Possession of.
The possession of a stolen firearm? I'm actually going through public safety article right now, and I'll be right with you about that.
Sorry, I apologize.
The theft of a firearm, it depends on the value of the firearm.
Okay.
Possession of a stolen one, I believe it's the same 5 years, but I am double checking that right now. And while I do that, and I'll come back to you, Delegate Griffiths, we'll go to, do you have another question?
I do in the meantime.
Well, go ahead. That's fine. We'll be right with that.
So
Go ahead.
One of my questions is, and again, it feels like on these gun bills over the last couple of years, we're nibbling around the edges of the problem, but not going after the problem. I'm not sure why. In the testimony on this bill, it was admitted that there's only 23 crimes in Baltimore City. And I only say Baltimore City because of sample size. I'm not trying to pick up Baltimore City. And because Baltimore City police testified on this bill, and I asked them this question directly, they said there were only 23 crimes that involve these type of weapons out of literally thousands of gun crimes in Baltimore City. Yet there's still a bill that sits on, on the other side that's coming over that would address some of those other things. So I guess my question is, what problem are we trying to solve here when we have thousands of crimes committed with illegally possessed weapons and 0.0001% of those crimes committed with these weapons?
Well, a couple things. That number isn't accurate. We've also received updated information that the amount of ghost guns that have been captured in the first quarter of this year, if we are going to continue at that rate, it will be double what the previous year was, right? If we continue at the rate of the past quarter for the next year compared to 2019, it's 6 times as many.
Sure.
So in 23 cases, they've been able to link an untraceable firearm with a crime, which is, I mean, I think that's a sign of excellent police work, right? Trying to trace an untraceable weapon to an actual crime. But there's many other violent crimes that are occurring where they can't trace these weapons. I mean, I think if you're trying to set your argument up to be the numbers don't prove that this is necessary, well, the number, how can you trace something that's untraceable?
Well, I mean, but we're not talking about untraceable weapons. We're talking about ghost guns. There's two different things. There's a difference from a weapon that's been scrubbed versus a weapon that's been manufactured, right? A 3D weapon and a hobbyist, or even somebody doing it for bad purposes and selling those weapons bad purpose, versus, I mean, not traceable and ghost guns are two very different things. So we're talking about having to double the rate in 2021 than 2020. That's still only 46 of literally thousands of crimes.
I mean, we can go back and forth about semantics, but a firearm that is created without serialization is by definition untraceable. That is why it was made without being serialized. So untraceable could include other categories of firearms, like one that has been, the serialization has been scrubbed off, but an unserialized firearm is a ghost gun. There's many different modalities of making a ghost gun. You can use one of these polymer 80 kits. That's what we're seeing. You could 3D print them. You could buy bits and pieces from Home Depot and then buy, a receiver that's been finished by you could, melt down Coke bottles or Coke cans to do this. But ultimately, if it's unserialized, law enforcement has told us that it's an issue.
Well, Lopez, you actually bring a good point that I actually really do appreciate. So this would apply to someone who has a pistol or stolen weapon with a serial number rubbed off. This would apply to them too, correct?
There's already, it's already in code that you can't possess or be the person who scratched off, altered. There's a whole sequence of verbs there to describe what you can't do to a serial number.
No, but that's in 5142 of the public safety article for removal or alteration of an identification marker number on a firearm. And that carries a 5-year, $10,000 fine. Sale, transfer, disposal of a stolen, regulated firearm, which also includes in the definition, a person may not possess a stolen, regulated firearm. That also carries 5 years, $5,000.
But
a $10,000 fine. Sorry.
So would this qualify? But but according to Delia Lopez, though, this would qualify them as ghost guns. Would this be an additional charge then?
No, because a ghost gun was created with no serialization. It never had serialization to begin with. That is entirely why this bill is necessary, because we already have it in code that you can't destroy the serialization.
I'm not trying to split hairs here, but I'm trying to reconcile this in good faith. A moment ago, you said any weapon without a serial number, and now and you said it wasn't just created weapons; it was weapons without a serial number. Now it's just manufactured weapons, which only account for the 23 or so. So I'm just.
I think.
Tell me what this covers.
Okay, let me. Think of things in like umbrellas, right? An untraceable firearm is any firearm that cannot be traced. That could be due to the fact that the serialization scheme was rubbed off or altered in some way, right?
Right.
There are other firearms that were intended to be used in criminal activity, and so they were created without any serialization at all. That is also untraceable.
Is this affecting untraceable weapons or weapons that were manufactured privately then?
This is about unserialized firearms because it's already in the code that you cannot alter a traditionally manufactured firearm in there. That's a serialization.
So this is for if somebody creates a weapon at home.
Yes, but it's typically for people who are creating an abundance of unserialized firearms that they will sell to prohibited people.
But this would
That
still
is who we're trying to get at.
But this still could potentially affect a hobbyist too.
No, because we created a pathway to make it legal for hobbyists to make their own guns in a legal way. And we clarified the ambiguity that's in the ATF code about how they can do that and what they can do with the firearm once it's been made.
And again, I would just like to say for the record, one thing globally about these bills that we're addressing, I think we all want to address the issue of illegal weapons, legal firearms. And even if this continues the trend of this year, we double to the number of almost 50 incidents with these weapons this year, it's still such a tiny amount of the overall crime we're dealing with. It's just interesting that we keep nibbling around the edges and not really trying to address some of the issues regarding this. I think that we all agree on. Thank you, Delegate Libs. I know you worked hard on this. I appreciate it.
Delegate Grammer. There you are.
Thank you, Mr. Chair. A couple questions for you. What is the original intent of the bill as drafted?
Delegate Lopez.
Do you mean Senator Huff's bill?
Yes, without the amendment.
Yeah, so the intent of Senator Huff's bill was to make it so that having a medical cannabis card would not be the sole disqualifying factor in trying to possess, purchase, transfer a firearm.
Is it true that the Senate has moved this bill for several years, but the House has never moved the bill?
It's true, and in fact, the Senate passed it unanimously this year.
Fantastic. Isn't it correct that several states have passed similar legislation aimed at addressing this?
That might be the case.
Okay.
I would assume, considering that Maryland can sometimes lead from the middle in terms of cannabis, so I wouldn't be surprised.
Fair enough. Isn't it the intent of the bill as drafted to fix that problem, that kind of loophole with medical cannabis and firearms as originally drafted this bill?
I mean, I can't speak to the intent of the sponsor, but certainly it's a short bill, and that is the information that we've been given.
A technical legal question for you. Isn't it true that section 13-3313A of the Health General Services article mandates that qualifying cannabis patients in possession of a legal supply of marijuana under the medical program may not be denied any right or privilege on account of the person's use of that medical marijuana?
I'm gonna assume yeah.
All right.
That sounded like a pretty comprehensive reading of whatever that was.
can I defer to counsel on that? I'd like a legal answer if I could, please.
Say it again, Delegate.
Section 13-3313A of the Health General Article mandates that a qualifying cannabis patient in possession of a legal supply of marijuana under the medical program may not be denied any right or privilege on account of that person's use of that medical marijuana. And I guess the section we're looking for is 13-3313A.
Yep, give me a second. Let me look it up.
Thank you.
You saying that we don't need Senator Huff's bill then?
Well, clearly
It
there's.
sounds like you're saying that we don't need Senator Huff's bill.
Well, we wouldn't if the state police were doing their job, but I guess that's what I'm trying to get
But it
at.
sounds like we don't need Senator Huff's bill then. Maybe this is just something that keeps getting sent out that's completely worthless and doesn't have a point.
Well, that's what I'm trying to get at here.
Oh, you're a crossfile too.
Right.
Yeah, okay. We'll go to the next question and we'll let council take the time to look that up. Delegate Moon?
What? I got a couple more questions.
Oh, you
Mr.
have more
Chair.
questions?
I
All
have
right, that's
more.
fine. We'll go Delegate Grammer first.
Okay.
Go ahead.
The next question is actually contingent on the answer that Claire gives me.
Okay,
Mr. Chair, my hand was up after grammar, but somehow it got lowered down. So I don't.
I saw that. I was going to you next. It's all right.
So,
She's apparently looking up the Health General article and I can go right over here. So one moment. Please.
Thank you.
So what the statute says is that any of the following persons acting in accordance with the provisions of this subtitle may not be subject to arrest, prosecution, revocation of mandatory supervision, parole, or probation, or any civil or administrative penalty, including a civil penalty or disciplinary action by a professional licensing board, or be denied any right or privilege for the medical use of or possession of medical cannabis.
So hearing that, by denying a Maryland resident the opportunity to purchase, transfer, or own a firearm within the bounds of that law, isn't the state of Maryland in violation of the Health General Services article?
If they are, then I'm sure that someone would have gone and they would have filed suit and taken that up with the Court of Appeals. Apparently they haven't.
Okay, and are we passing the original portion of this bill
Yes.
expecting that it will be found legal just as it has been in other states?
We are passing this and adding an amendment to the bill that would address the issue related to ghost guns.
But is it assumed, because this has been mentioned in the past, that this portion of the bill, the original portion of the bill, would be illegal? And I just wanted to clarify, are we passing the original portion of the bill expecting for it to be legal just as it has been in other states?
I think that there would probably be some involvement of the courts to determine whether that would conflict with 5133 of the public safety article.
Okay, so I have a few brief comments and then one more question. I want to point out, as a matter of procedure, the sponsor of the bill can withdraw the bill at any time, and I do respect Delegate Lopez, but this bill as amended will never survive the Senate, and the bill's sponsor will assuredly pull it. So the public is aware the bill is very narrowly tailored to fix a problem in the law as originally drafted. If we add this amendment, which is 20 times longer than the original bill, this bill is dead. We should aim to fix problems in our public safety laws. We are failing veterans and medical cannabis users by trying to use this bill as a negotiation vessel. But I'm glad that we finally had an opportunity to put both the legal questions about this issue and the politics of the General Assembly on public record. This is all admissible in court, and is added to the legislative record of this issue. The state of Maryland allows for the growth, transportation, distribution, and sale of marijuana in violation of federal law. It's very convenient that state law benefits those who donate massive contributions to office holders, but ignores this loophole in the law to the detriment of medical cannabis users, most of whom are veterans. This is clearly arbitrary and capricious. Additionally, Mr. Chair.
Point of order.
What's the point of, what is?
I believe we've already heard this testimony. This was his testimony when he testified.
No, it is not. And I'm getting to the point here.
If you, Delegate Grammer, go ahead and get to your point.
Additionally, Mr. Chair, today we have passed legislation that would allow for the hiring of a person who has purchased marijuana illegally to become a law enforcement officer. So we are willing to issue a person a weapon and give them the privilege of authority to use lethal force if they purchase marijuana illegally, but we deny the right for a private citizen to purchase a firearm solely based on their status as a qualifying patient. State employees buy illegal marijuana, they get a gun. Private citizens with a card, they get no gun. This is clearly arbitrary and capricious and a violation of our own law. So here's my question, Mr. Chair. Now that this is all on legislative record, if a person who has a medical cannabis card goes to purchase a firearm, let's say, for example, I'm a card holder and I would like to teach my son how to shoot using a .22 and teach him safe use of firearms, just as my father taught me. And I go to purchase a firearm and I'm denied that right arbitrarily. How long should we wait before we sue the state, just as you've mentioned? Now that we've answered the legal questions publicly and demonstrated the arbitrary and capricious nature of the law publicly, and we have demonstrated the petty politics of the legislature.
Mr. Chair, I have a point of order too. Is there a question pending?
Yes.
This is
Hopefully somewhere in my near future. One can only hope.
That we have demonstrated the politics of the legislature have preceded the rights of Maryland's veterans, and we need to go to court. How long should medical cannabis patients wait before they litigate? That is the question.
That's a question that they themselves can answer. Delegate Moon.
Thank you, Mr. Chair. So I just have two questions. One is for the maker of the amendment. I get the points everybody's making. Obviously, those who wanted one bill versus the other bill would rather see those bills go straight. But seeing as how the opposing chambers have not moved those bills, I think this is a good opportunity if people want to meet in the middle. So here's my question for the maker of the amendment. How ready for prime time is, I guess, the ghost guns issue? It sounds like you've, taken in some feedback. Have people seen this amendment text now to be able to come in with an opinion on it? So that's one question. Why don't we start there?
Sure. So by people, let's start, use that to be stakeholders, right? Law enforcement from Baltimore County, Prince George's County, Montgomery County has seen it. State's attorneys from all of those areas, and including some rural counties, have seen it. The people in the advocacy space have seen all of these amendments and are fine with it. Basically everyone who's willing to have productive conversations with me and continues to add value in those conversations has seen it. And there's peace in the valley here, which is very rare, even within all of the gun violence prevention community.
All right, thanks. And I just have one sort of yes or no question for Delegate Grammer, which is, you said something about you think the senator across the street is going to withdraw the bill if it has this amendment on it. And I know you had another one, similar bill, and I'm curious if you would withdraw the bill if this amendment went onto it.
I would 100% withdraw my bill if this were on it. And frankly, I don't think the senator would. I can't speak for him, but I am almost completely certain that he would withdraw his bill if this were on it.
Delegate Ron Watson.
Thank you, Mr. Chair. I don't think this bill is going anywhere with the medicinal marijuana piece, period. And, I had looked into this not long after Grammer proposed his last bill. And my reading of it goes back to the Gun Control Act of '68, which was reaffirmed by ATF in 2011, that medicinal marijuana users cannot own firearms, period. And yes, it is a paradox. We get it. Graham was very eloquent in his speech, but this bill isn't going anywhere with that medicinal marijuana piece in it. And so if we want to move the ghost gun piece, we need to extract that medicinal marijuana piece back out and push the original bill with its original intent. And that's my comment.
All right, Delegate Cox. Make sure that your others are muted. Feedback.
Thank you, Mr. Chair. And I was going to, can you hear me?
Yes.
Okay, thank you. Just two quick things. I wanted to just ditto what Delegate Watson just said. I think that procedure and the fact that this is a professional body, that we all need to adhere to basic principles and rules. And I think that this violates two rules. First of all, the last minute that it's brought forward. And then secondly, it's a different subject. So that would be my concern. The other thing, though, that I wanted to ask, in the bill itself, as it's amended now, it says that a person in possession of one of these homemade guns or manufactured guns must conspicuously engrave the information if they're in possession of the firearm. Then if you read down the next page, it says that the firearm may be transferred to family members. So my question is, how many times do you have to engrave this as it's written? It looks to me like every time you transfer the gun, you have to, it's like a different status gun for some reason. It doesn't make sense. You have to re-engrave it with a new possessor. Is that true?
So Delegate, you asked this question in the hearing and the answer is the same. If you are making a firearm for yourself, it has to be made explicitly with the intention of using it yourself. So there's only one name that needs to be engraved on the firearm.
Okay, but in the bill as amended before us now, it says you can transfer it to a family member who has an HQL.
That's correct. And it would follow the same rules as a regulated firearm, where you would have to go to an FFL to conduct the transfer, and there would be a record of it. And because of that serialization and all the identifying information, there would be a record of it.
But it says, though, in the language as postured, it says the person possessing the firearm must re-engrave it. So I understand, you can't transfer under this bill. You won't be able to transfer to anyone other than family members. But, for people who have large families who might pass things down through families, it looks like a problem. That's what I just wanted to clarify that. But thank you.
Delegate Juanica Fisher.
Thanks, Mr. Chair. Thank you, Delegate Lopez, for your thought and work on this legislation. I wanted you to talk a little bit more about the ongoing issue of ghost guns. I know you and I had an offline conversation. I actually was in the middle of a case in Calvert County, and I had a state's attorney actually approach me about ghost guns and how worried and concerned they were, and connected them with you. As you're more expert than I wanted you to talk about those kind of conversations and what's going on. And I know for people offline, that happened between you and me real time in like the last couple of weeks, while I was dealing with that with a client with a case down there. So I was wondering if you could talk about that and any other issues that are happening with crime and with the issues that are going on with ghost guns. Thank you.
Sure. So I gave a whole bunch of statistics during the hearing, and we have updated numbers, but essentially, it's growing exponentially as a risk to communities, specifically in urban areas like Baltimore City, Prince George's County, Montgomery counties. Like we're seeing these being seized at double, triple, quadruple the rate that they've been seized in the past. And I think that when we started this conversation about unserialized firearms, so much of it was about 3D printing, because that was the thing that was in the news, and that's kind of the thing that people could conceptualize better. But from the beginning, this has always been about bad actors who are setting up unregulated, unlicensed gun manufacturing operations and then selling them to prohibited people, right? And it is expensive to make one of these yourself. It's expensive to make the first one, but once you have the equipment, you can crank them up, and the profit margin is high because you're selling to people who would otherwise never have access to a firearm. So that's one part of the issue. And like I said before, we've all seen the video that was circulated by the Baltimore police of, number one, a man being shot by a polymer 80, and then the police officer running after the shooter, and then the shooter coming after the police officer with a polymer 80. I mean, these are deadly weapons. The other part of this that was on my mind when the hearing was happening, but I didn't really want to go into it because there's a lot of ongoing investigations and everything, is the connections of unserialized firearms to white nationalists and white supremacists who are exchanging this information in all sorts of clandestine online forums. We've had people in our state arrested for this in, the hotbed of gun crime, Silver Spring of all places. These men were associated with a group called The Base. There's also been people arrested that were associated with another white nationalist movement called Patriot Front. And the conversations that I've had with law enforcement in those more rural areas is that they're seeing these guns being used in, your kind of traditional robberies and drug trafficking and things like that. But they're also seeing more illegal firearms by way of unserialized firearms with white nationalists, people that they're arresting for other things, and they just happen to notice that they have these unserialized firearms too.
Right, Delegate McComas, then Delegate Williams, then Delegate Malone. Delegate McComas?
Mr. Chair, I guess I'm a little confused, and that, consider that my normal process. There were a number of bills that we heard, and I got the impression that there was a study in 2016, it was a national survey of prisoners, national survey, and only 2% of them used legal guns in their criminal activity. So that means that a lot of them are stolen. And I know Delegate Beitzel put in his bill, which was 633, hasn't gotten a look at or anything, where it increased the penalties for stolen weapons. And most of the guns are stolen. And in these crimes, they aren't ghost guns, but they're stolen. And yet nobody's, picking up on that maybe we need to make the penalty more severe and maybe have mandatory minimums. So that was one question. The other thing is this Delegate Attar's bill, the straw purchase. She's very concerned about that. And that was HB 669. So I'm wondering, of all the bills that we could have plastered on Delegate Senator Huff's bill, which was actually less than a full page, why we didn't consider some of these, and the committee wasn't consulted, but we get the ghost guns. Now I know we got barraged with a bunch of people, saying where is it? I had nobody from my jurisdiction email me, but there were like mass mailings. So I guess I just kind of wonder why the committee or the powers that be in the committee selected ghost guns as opposed to some of these other worthy bills to tack on to this very small, simple bill. Anybody answer that?
Sure. The committee is taking this issue up because, one, Delegate Lopez has been working extensively on this issue and has been continuing to work on the issue during the legislative session, even though it wasn't clear that we were going to be able to go forward on it. But two, we are seeing a significant growth in many different places, many different jurisdictions in the state, where these kinds of guns are being found, and they're being found in connection to crimes that are happening. They are unregulated. And to that end, that makes it, I believe, an important part of the conversation that we need to have with regard to gun violence, not only in Baltimore City, but in other jurisdictions in the state. And for that reason, that's why we're considering this amendment tonight, and why we're certainly going to continue this conversation, I'm sure, about ghost guns both this year and next year. Delegate Nicole Williams.
Thank you, Mr. Chair, and thank you to everyone who's worked so hard on this. I think you answered this question already, Delegate Lopez, when Delegate Moon was asking his questions. The Maryland State's Attorneys Association, are they okay with the amendments that you have proposed?
Yes, they are. They felt that the original language didn't give them enough prosecutorial discretion, and so I took that out because I understood what their point was.
Okay,
so they're all good.
Oh, good. And just because a bill is short doesn't mean it's necessarily a good bill, nor if a bill is long doesn't necessarily mean it's a bad bill. And so I just want to thank you for bringing forth this legislation. And so I just wanted to make that comment since folks were making comments. Thanks.
Delegate Malone. Oh, Mike, your sound isn't working again.
I'm going to put him back in the waiting room and bring him back in. And
okay, we're going to give him a second chance.
Hold on 1 second.
No, we do want to hear from Delegate Malone.
And in the meantime, should I move the previous question or whatever?
Well, we're going to let him. We will move the.
I just mean have it standing out there.
No, that's fine.
Got me?
We'll hear from Delegate Malone, and then we'll move the question. Delegate Malone, can we hear you now?
So once again, we'll hear argument tonight. We'll hear argument on the floor, but it's going nowhere in the Senate, in my opinion, and from my information. I move the amendment unfavorably.
Second.
I'm sorry, I missed the issue. What did you say again?
Move the amendment unfavorably.
Second.
I don't believe that you can move an amendment unfavorably. The question is going to be first, whether the amendment is moved in the first place, because we haven't actually moved the amendment.
Move the amendment favorable.
That we will take.
Why can't we move it unfavorably?
You can vote against the amendment. You can vote against the amendment. But we make motions on the bills favorably and unfavorably. We don't make the motions on the amendments favorably and unfavorably.
Well, I'll admit, why not?
Well, Mr. Chair, didn't Delegate Moon just before Delegate Malone move favorably on the amendment by calling the question?
I think by calling the question, you could argue that in either case, if the amendment fails, it doesn't go on the bill. If the amendment passes, it goes on the bill. So if you're against the amendment, if you're unfavorable towards the amendment, just vote no. I don't think there's a difference in what happens next. It's just up to you as to whether or not you want to vote for or against the amendment. But to your point, Delegate Malone, you're going to be against the amendment. We'll do it that way. There is a motion on the amendment, and we will take a vote on the amendment. Take a vote on whether to adopt the amendment. And we'll do it by raising hands. All in favor of the amendment, please raise your hands.
We can't have a roll call?
Delegates, I'm going to go through the names right now. Delegates Lopez. Can't tell what Delegate Cham's doing.
This adds the medicinal marijuana piece too?
This is the amendments that will be added to Senator Huff's bill.
Okay.
I see Lopez, Atterbury, Williams, Conaway, Fisher, Davis, Moon, Bartley, Jones, Shetty, Crutchfield, Cardin. Those opposed to the amendment?
Yeah.
Grammar.
Can I explain my vote, Mr. Chair?
I will. I'll let you do it in a second. Let me get the hands and then I'll let you explain your vote. Delegates Grammer, Arakan, Cham, Cox, McComas, Watson, saw Cox, Griffith, and Malone. Let's see, 12-8, Delegate Grammer to explain your vote.
Thank you, Mr. Chair. It's April 7th, 7:58 p.m. We're debating Senate Bill 190. And I don't think we're really sincere about either bill. If this is if this is the way we're trying to get this done, we shouldn't be using people's rights as a negotiating vessel. Where people are illegal, we should make people legal. We should provide medical cannabis users the same rights everyone else has. And that's why I'm voting no.
All right. Seeing none, the amendment is adopted. We're on the bill as amended. We're on the bill as amended. There's a motion for a favorable on the bill.
Second.
And a second. Is there further discussion on the bill as amended? Delegate Moon, were you wanting to talk? Okay, Delegate Griffith, go ahead.
Thank you, Mr. Chair. And to echo some of Delegate Grammer's points, it's certainly disappointing. You know, we have a lot of veterans who use medical marijuana, who are recovering from injuries, dealing with PTSD, a variety of things, and it helps them get through and gets by. And they also have a right to possess these weapons. And to conflate these two issues does one of two things. Either makes both issues very important or it makes both issues not that important. Either one is, you know, so I'm not sure which one we're going. Is the ghost gun issue not really that important, so we're going to use it to throw in this bill, or is the medical marijuana issue a really important issue, so we're combining that way? Whichever way, you know, I think these two issues should be tackled independently, and I'm just a little disappointed this evening after all the work we've done this session.
All right, Delegate Moon.
So I just thank you, Mr. Chair. I just want to say I want to make it clear on my motive that I'm not playing games. I don't take both of these bills in a not serious light. That from where I sit, I'm familiar with Senator Huff and Grammer's bills, and we've had them for years. I'm aware they passed out of the Senate unanimously, and they just haven't moved here. And so I know some won't like the other bill, the ghost gun bill, coming onto this one, but I will tell you, we've done this in the past on other issues where we came to similar disagreements. I did it to one of Senator Reedy's bills a few years ago, and guess what? He got his bill. And we actually advanced some of the discussion around the impasse on that issue. And so I don't think this is a bad faith move. I've never really had a problem with Senator Huff or Delegate Grammer's bill, to be clear. So I think this is a legitimate effort to put the ball forward. And like I said, the minority party can vote against the bill if they don't like it. But that doesn't mean they should detach the two parts if they think one of them is going to pass. I think that would be a mistake.
Delegate McComas, then Williams, Lopez, Grammer. Delegate McComas.
I'm just going to say this. I've been around a little bit, and I've experienced some poison pills put on bills in the past, and this is basically a poison pill. But it's a poison pill, maybe not to us because we're in the arena, but to the folks that are outside of the arena, which are our constituents and the public at large. And this is sausage making at its absolute worst. And they don't understand it, and we're just throwing stuff in because it just very, what do I want to say? Just like connects, because it's, you know, you can say, well, it deals with guns, so it's single subject, but it really isn't. They're totally two different focuses, and I think that this is why Congress has such a bad name, and the Maryland General Assembly is going to have a bad name. people, we're known as the Maryland General Asylum. So that's all I'm going to say. And I don't think people are crazy. And I know Delegate Lopez has worked very, very hard on this, but this is not fair to either Huff's bill or Grammer's bill or to Delegate Lopez's bill. And so thank you.
Delegate Lopez.
Sure. So there are comments made before, and Delegate McComas kind of underlined them too, basically just about like the cynicism of adding these two pieces of legislation together. And I can tell you, it is a good faith effort. I come from a family that has very severe addiction issues. And if there's any way that we could destigmatize medical cannabis as a way for people to not look to opioids for pain management, I'm all for it. And if you look at my voting record, you'll see that's been the case for a while now. I can understand why doing things the last week might make people cynical, but we still have 5 days to go. And this is a 90-day session, not an 85-day session. We're expected to work the entire time. And so, the timing argument to me doesn't really hold up because, we've had a public hearing about the ghost gun bill. It was almost 4 hours long. Almost 50 people testified. Delegate Hornberger gave testimony on his bill, which was only 3 minutes long. But so this really, it might seem fast, but it's, I just would caution people not to be so cynical.
Delegate Grammer.
Thank you, Mr. Chair. I just wanted to respond to Delegate Moon, and I do appreciate his strategery and his nimbleness in getting legislation passed. But if you remember several years ago, the bill that he referenced, it wasn't a bill that anyone opposed. It was more of clearing a log jam. And I believe the entire legislature supported that bill in the end. This is not the case with this bill. This is borderline bad faith. It's if I took a Democrat bill and I put some pro-life amendment to try and ram it through. Like, these are totally separate issues. This should have its own bill. It does have its own bill, and it's not going anywhere for a reason. And the public can look. It's April 7th. Every day after this, a year from now, this bill will not have passed. And I appreciate the efforts and everyone's concern, whether we agree or not. But this is not the way we should handle this.
Delegate Cardin.
Thank you, Mr. Chair. And again, I wasn't going to actually speak, but I just want to briefly comment to Delegate McComas's comment, which is that I do not believe that this is a poison pill. I do not believe it's games. What I believe is that we have a good faith effort to pass a bill that we believe is a good, smart bill that we want to pass in Delegate Lopez's bill. Delegate Grammer's made a good case for the Huff bill being a good, smart bill. And as Delegate Moon has already said, this is called compromise and working together for everybody to get what they want. So that is the reason why I think this is a good faith effort to try and bring us all together. And I look forward to us hopefully being able to pass the incomprehensive bill together as one unit, and the Senate and the House getting together and working together on both issues.
Delegate Griffith, and then we're going to call a question.
Thank you, Mr. Chair. Quick question. I know we're talking about effort and time and trying to work this through. I guess my question is, why were we just notified of this an hour ago, or around 6 o'clock, an hour before the vote, to have a chance to digest this and consider this? I guess that's what I'm trying to understand. And also to Delegate Cardin's point of being a compromise, compromising two very different issues. We're not compromising the ghost gun bill because we're moving the ghost gun bill, or are we compromising on the medical marijuana bill because we're looking to move the medical marijuana bill? If we want to leverage one bill against the other, then we pass those two bills alongside each other and leverage it that way. But to merge them is now making people make a choice, which is not a compromise. It's making us make a choice. So very concerned, very concerned.
Seeing no further discussion, we will take a roll call on the favorable motion. The Vice Chair,
Yes.
Delegate Arakan,
No.
Delegate Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Yes.
Cox,
No.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
No.
Griffith,
No.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
No, in particular, in explaining my vote, we are becoming more like Washington, and it's very disappointing.
McComas,
No.
Moon,
Yes, and I actually think this is compromise unlike what we see in Washington.
Shetty,
Yes.
Cham,
No.
Damn.
can only vote once, Delegate Cham. I'm sorry. Ron Watson,
A soft yes.
Williams,
Yes.
motion passes 13-7. All right, that concludes the voting session for this evening. We will have more legislation tomorrow. I will say that there's going to be a long voting session on the floor. And then I think they're going to try and finish by about 3 o'clock. My intent is to have a voting session for committee bills probably on or about 6 o'clock tomorrow night. Might be a little later than that, as yes, I understand there are some obligations in between. So with that, we'll give notice of that voting session on the floor, but this has been a voting session of the House Judiciary Committee, and have a good evening.